Attendees are starting to enter the room.
We're just going to give everyone a second to pile into the room here. And once we get our critical mass of attendees, we'll go ahead and get started for everyone who's already watching. We are, people are coming in now.
Yeah, we have about 3/4 of the audience that's registered so far. Hang on. Let's do.
Folks, if you've joined us, we're just waiting for some additional attendees to join the video conference, and then we'll get going. So just stand by. We should be going here in just a couple minutes. Steve, looks like the participants have the participant counts stabilized. I say that, and then a few more popped in. So it's 10:02. We'll go ahead and get started, and folks can join us as they come in if they haven't already joined us. But first, I'd like to thank everyone. Wish you good morning. My name is Chris Lewis. I'm the president of the Maine Trial Lawyers Association. I'm joined today by Justin Andrus from the Board of Overseers. First, we're going to have a word from Jack McGinty of Ringler & Associates. He's a sponsor of the MTLA, of this CLE, and has been a good friend to the organization for a lot of years. So with that, Jack, take it away, please.
Good morning, folks. It'll be a brief good morning. I know you have stuff to do. Chris and Steve were kind enough to let me say hello since I haven't been out to see anybody in quite some time. I wish I was up in Aroostook. It's one of my favorite CLEs every year. I hope you're all well, and I just want to let you know that Donna and I are available. We're still working. I'm from home sometimes. I'm back in the office mostly. If you need any structured settlement assistance or even some questions, give us a call. Enjoy the seminar today, and enjoy your weekend too. Thanks. It's great to see everybody.
Thanks, Jack. And I tried to Zoom background of the Northeastland Hotel, but I was unable to do that. So you're just going to have to get my home office here. But we'll go ahead and get started. And again, looking forward to next year when we can actually go in person to Presque. It's always a great CLE and always a great picnic afterwards. And just looking forward to that next year. So with that, I'm going to go ahead and turn things over to Justin Andrus from the Board of Overseers. Justin.
Good morning. I am Justin Andrus. I am Assistant Bar Counsel at the Board of Overseers. I'm going to need to ask your forbearance today, everybody. I have a cast on my leg, which makes me move funny. So if I seriously bear with me. I see on the list of attendees a number of people who I know, but many more I don't. So I always want to start CLEs, but just briefly explaining who I am and the approach that we're taking to working with you, including with respect to harassment and discrimination training and to dealing with incidents that arise under Rule 8.4G. I joined the Board of Overseers last fall in September after 18 years in private practice. I have been a practitioner. I know what it's like. I have dealt with the challenges. I have dealt with the complaints, the clients, the opposing parties, the judges. And in doing this job, it's my hope that I can bring a perspective of a very recent practitioner, both to bring a practicality to the enforcement of our ethical rules, but also so that you can have confidence that there's somebody there who knows where you've been recently. So as part of that, one of the things I did not know until I joined the Board of Overseers is how we really see the bar and how ethical and strong you really are. And so I've taken to starting with some of that because there's a perception, and I think it's really enhanced in the context of the harassment and discrimination stuff where we're really looking at what feels like legislating some form of philosophy or morality, that we're here looking to zap you. And that's just not the case. So I thought it was interesting when I joined the board to learn that we closed 2019 with file number 482 on the year. And of those, 13 cases resulted in something other than a dismissal, and 4 resulted in some action greater than a reprimand or admonition. It's a very, very small fraction. And that's not because we won't prosecute real problems. That's because you are ethical and you do practice well, fairly, and honorably, and we know that. And I guess I just want to make sure that that every group I talk to knows that that's the perspective that we're genuinely coming from. As part of that, I also want to extend the invitation. I know you know that we have an ethics line. I know you know that Bar Council staff is available to you, but I think not enough people take advantage of it. We're there. We want to work with you. We want to help you practice ethically. We want to do that as practically, as often, as early as we can. I would rather take 100 ethics line calls than prosecute a single violation. And that's particularly, I think, important in this context, because there seems to be a lot of uncertainty about what the harassment and discrimination rules actually require of an attorney and what constitutes a violation and how we're going to address that. So please call us. We would like to work with you and not against you. I'm going to try and
Just give you 1 second. I forgot to say this at the start. We're really hoping this can be an interactive program. To that end, we're working on, there's a raise hand function in the chat. And for those of you who don't know where the chat function is, if you go to the bottom of your screen, if it's a PC, there's a button that says chat. You click that, you'll get a list, a Zoom webinar chat function. You can either message myself, message the group as a whole, or you can raise your hand and we're going to make your turn your microphone on and you can ask a question directly. And this is going to be a lot more interesting for all of us if there's some give and take. So we really hope that's the case. So please feel free to chime in.
Thanks, Chris. And I agree. That's exactly where I was about to go as well. And I want to just add my encouragement that you participate. If you want to chat a question to us, if you want to ask a question that you don't necessarily want public, you have that option as well. But to the extent that we can have a dialogue, I would like that, because I think this would be more useful than a talking head talking at you in this format. It's a very difficult format to provide a meaningful lecture through. Turning then to substance of the presentation, there's been a lot of, we've gotten a lot of feedback formally. I've gotten a lot of feedback informally from lawyers who have some misconceptions about what's actually required of them by the rule and what they need to stay out of doing. And particularly this year, I think it's really important that we communicate effectively that the courts have promulgated a statement promoting racial equality and freedom from bias in the judicial system, and that as an agency of the court, the Board of Overseers adheres to that, and we share in the court's view that we have a direct and fundamental responsibility to dispense justice, participate in the dispense of justice without any hint, any appearance of any bias. And we try to do that. But we also are not the thought police. And in the feedback that we've gotten and that I've gotten informally to these sessions, there have been a number of people who have expressed the concern that the Board of Overseers is trying to mandate a particular thought process. And that's not the case. So probably by this point, a lot of people have read to you what the rule says, or you've read it for yourself, you've certified that you've done it. But the rule prohibits you as an attorney from engaging in conduct or communication in the course of your practice that is harassment or discrimination based on suspected classes. The rule does not require you to think differently than you may already think. And we would encourage, and I'm going to get into this, we encourage some some perhaps changes in thoughts about how you address your other attorneys, how you address the courts and your clients, witnesses. But for those who have the fear that we are here to tell you what to think, we're not here to do that. Go ahead, Chris. Oh, I'm sorry. I got an indicator there. Sorry about that. The key is to limit your conduct to conduct that is specific to the case, to the practice, and to avoid conduct or speech that singles out or specifies working with an individual based on their own characterizations or characteristics. So what does that mean for you? What we want to see is that you serve your clients through competence and preparation, and that you do that to accept and further the mission of the courts and of the bar, and that you don't express the prejudices. We would really like to see that you don't experience the prejudices, but if that's not possible, that's okay. One of the things that I hear a lot is from people who believe that they're good folks and they don't understand the need for so much focus on avoiding biased behavior. And I guess I want to make sure that you all recognize that we know this. But one of the most difficult things in, excuse me one second. One of the most difficult things in trying to practice in a way that's free from bias is identifying those times and places where we may come from places or positions of bias that we don't recognize. And so I think that for the most part, people are out there practicing in a way that is intending to be kind or is intending to be non-discriminatory or non-biased. When I was in private practice, I had a young attorney working for me. She was the last associate to join my firm, was with me for several years before I left private practice to come here. As an example, she pointed out to me behavior I was engaged in that evidenced substantial bias, and I didn't intend it. So the realization was that we would frequently, as a firm, would go to lunch or we'd have dinners or we'd have other events, and that she'd come to the table and I would stand. But one of my male associates came to the table, I might not, or I'd open the door for her, I'd offer to carry things for her, things that I intended to be as polite. I was raised and trained that that's how a gentleman behaves. What I didn't understand at the time was, until it was pointed out to me, that in behaving in this way that distinguished her on the basis of gender, even though my intent was to be polite, even though my intent was to be kind, I was signaling to the people around us that she was in need of protection, and that she was in need of being treated differently than in others. And in doing that, that I was communicating to them that they should also treat her differently. That's the best case. Perhaps buried in there is an element of believing it, as opposed to having simply been conditioned to respond in that way. And so we see a lot of things like this. And solutions don't require you to stop being kind or considerate or polite. My solution was very simple. You could probably imagine. I just stood up when anybody came to the table, opened the door for everybody. It allowed me to continue being polite, and it eliminated the aspect of where I was singling this person out. I suspect that most of you who are being asked to participate in these things yearly and repeatedly are in the category of people who don't actively discriminate, who don't choose to mistreat somebody consciously, but who are probably nevertheless trying to, inadvertently, not trying to, on occasion, interacting with a person based on an immutable characteristic rather than on their on the merits of the case, on the merits of the situation. We see it in gender far too frequently. I hear from colleagues, members of the bar, far too frequently examples of this happening. It is often men who are doing it to women. It is occasionally women are doing it to men, but men do it to men. And I presume women do it to women. I haven't had that experience. But in our interactions, one of the protected categories is age. In our interactions, we frequently will denigrate or see denigrated a young attorney or an old attorney based on being young or based on being old. And probably for the most part, those things are unintentional. They're things to look out for as triggers. So the first attorney I worked for called me Junior all the time to everybody. Have you seen Junior? It serves no purpose other than to undermine the person. And again, it's commenting on my characteristics rather than on the quality of my preparation or the quality of my skills or the quality of my abilities. And so really what we're asking is that you consider in your speech and consider in your conduct that any argument or statement that you make that includes as an element something specific about the other person, as opposed to about the matter or the case or the situation, that you consider that suspect. I see a hand, Chris. I don't know if I can authorize that or.
I actually just asked Marianne to be kind enough to raise her hand just so we can make.
So we know it's working. All right.
Good job. It's working.
Okay. It's really that simple, I guess, is the long and the short of it. In your interactions related to the practice of law, we would encourage you to stay focused on being competent and prepared and keeping your arguments and communication limited to the scope of the situation, the scope of the matter, the case, if it's a court-based case. And that you avoid the temptation to work into the conversation, comments, or behaviors that relate to the characteristics of the individual. I think we would all agree that trying to soften an opponent attorney or a witness judge up by assaulting them would be inappropriate. It's the same effect. By keeping it simply away from those immutable characteristics, you can avoid the possibility that as a person who's trying to adhere to the rule, you're nevertheless running afoul of it. Excuse me one second. So then leads to a discussion about the people who are troubled by the rule itself and who are not in the category of people who are trying to adhere to the rule or believe they naturally adhere to the rule, but who may occasionally run afoul of it, but rather to people whose belief structures take them to a place where they're in opposition to the rule. And one of the things that we want to make sure to communicate is that the rule does not require you to offer representation to a person that you don't believe you can represent. We've gotten a lot of my informal feedback has been about the issue of, are you required to represent somebody that you don't feel like you can competently represent because of something to do with your relationship with them? And the answer to that question is no, you're not. Although you should be aware that lawyers are public accommodations and that the Maine Human Rights Act may, and I'm not here to give you legal advice about the applicability of the Maine Human Rights Act, but the Maine Human Rights Act can be a source of trouble for you if you choose not to represent somebody based on a characteristic. Go ahead, Chris.
Justin, just, I think it'd be helpful there to give some examples that you've received at the overseers. I mean, what do you mean that if somebody's not competent to represent a client because of their relationship with that person? What do you mean by that? So, and I want to be careful to make a use-mention distinction here in responding to that, because some of the concerns that we've heard
I don't share personally necessarily and are not the position of the Board of Overseers. But a person who does not believe that they can represent a transgendered person because of their religion, the final clause is an example that we've got. The final clause of 8.4G, just number 4, is declining representation or limiting one's practice to particular clients or types of clients is not regulated by the rule. That's not consistent, in my view, with the main Human Rights Act. And as attorneys as public accommodations have a responsibility to not engage in discrimination that's unlawful under the rule. But what we found is that there are people objecting to our enforcement of Rule 8.4G on the basis that they're going to be required to represent people who they don't feel that they can have an effective attorney-client relationship. The reason I use the word competence is that no attorney should be representing somebody they can't work with. In my view, attorneys should be able to work with most people. Okay, that's not an endorsement of that perspective. But for an attorney to be forced to represent the client who the attorney is going to then undermine creates a competence problem. So that's why I used the word competence earlier, Chris. What we are trying to regulate is once an attorney is involved in a case or in a matter for a client, or involved in managing a law firm or engaged in other conduct related to the practice of law outside of a specific case, that the attorney not then engage in that discriminatory or harassing behavior. We have, as part of that, we've had the attorneys raise First Amendment challenges to Rule 8.4G, suggesting that we're infringing on particularly religious liberty issues by requiring people to engage other people in ways that they don't agree with. And I guess it's important to me to point out that we're not talking about protected speech. Attorney speech is regulated in a lot of contexts, and that the First Amendment doesn't provide blanket permission to engage in speech as an attorney. The U.S. Supreme Court's upheld attorney speech regulations regularly. They seem to be loosening in the advertising, or have loosened in the advertising perspective. But perhaps the easiest example is the rules of court prohibit an attorney from communicating in certain ways. And attorneys have been prosecuted here in Maine for violations of those rules, notwithstanding the guise of the First Amendment. Probably the place we see this most often is in the context of pronouncing and in the context of dead naming people.
What do you mean by
Yeah, dead naming somebody is what we call it when a person who has either is transgendered or multigendered or has, for some other reason, changed a name to better reflect, for any reason really, but generally to better reflect who that person perceives themselves to be, and then persisting in using the old name. And it's pervasive. I have a friend who has been transgendered for 20 years, and in the context in which I know her, which is not the law, in the context of which I know her, people still persist in calling her by her masculine name from 20 years ago, and it serves no purpose but to be controlling and domineering. But we hear frequently that asking an attorney, or I hear frequently asking an attorney to use a new name or to use a gendered pronoun that doesn't suit that attorney's perception of the person, or to use a non-gendered pronoun which doesn't suit that person's perception of the language, maybe, is essentially a First Amendment violation. And disagree with that, but also would point out that we take those allegations seriously. They can be the basis for discipline, and we don't want to be disciplining people on that basis. It is no problem for almost any of us to use shorter form or long form first names, like for example, David or Dave or Jonathan or John, we honor those things. Somebody says they want to be David and not Dave, we rarely continue to make that mistake. And it's no different, no greater imposition to assume or adopt pronouns that the person has started to adopt or asked to adopt. If there are people in the audience willing to share their concerns about how they see the rule being enforced, and last year in some of our earlier presentations, we've gotten a lot of people who have been able to identify ways in which they feel like the rule is constraining what ought to be permissible behavior. It would be helpful to hear that. And if it's difficult, especially right now, to stand up in this context and share that, you can reach out to me offline, or you can filter it through another person. You're not trying to shame anybody, but we want to address the need to act structurally in a way that supports everyone in equal access and participation in the courts, with a mechanism that makes that possible without causing other people to feel alienated or in direct opposition to the court system otherwise. So I think that it leads to really the issue of what do you do? What do you do when you become aware that there is discriminatory conduct occurring, harassing conduct? What if you witness it? What if it's in your firm? What if you're experiencing it? To this point, we've had few instances of formal discipline or requests for formal discipline that have related to Rule 8.4G. And I think that has to do with an inherent problem in the culture the rule is trying to overcome, which is that for somebody to come forward and complain about conduct can result in trivialization and re-victimization of that person, can make them a pariah. We want to make sure that if you are a person who has either experienced or otherwise witnessed conduct that is either harassing or discriminatory under the rule or otherwise problematic, you can connect with us and we can try and help navigate that in some ways that don't require you to be stigmatized or don't require you to face the fear of being stigmatized as a result of doing that. I'd like to think you won't be stigmatized. I think that if there were a significant event and a person came forward and bore witness to that, that the bulk of our bar is supportive, and the bulk of our bar will recognize the need for that. We're self-policing, and our excellence is based in holding each other accountable and helping each other through processes. But here we are a year and a half into this process and not seeing the grievances. And so if you are in a position in which you see or you experience harassing or discriminatory conduct, you can call us, you can email us. There may be processes, there are processes that may be applicable to specific instances that we can help navigate through. Again, our goal from the outset is not to punish. Our goal is to promote the integrity of the judicial system by promoting excellence in the bar. And in many cases, particularly if they're cases of inadvertent or unknowing reliance on sort of conditioned, biased behavior, going back to my example of treating my female associate differently than my male associates without realizing I was doing it. Frequently that's not stuff that requires discipline, but that's something that we could facilitate a dialogue. We have options, including the Alternatives to Discipline program and formal alternatives to discipline, where we can work with attorneys. And we can do that in a way that doesn't require making public necessarily the event, or that the event happened to you, or that you witnessed the event. Again, I would like to think, Chris, did you have a thing? I saw you. Okay.
When there's a good point here, I just have a couple questions for you. But is this a good
Yeah,
time?
hit me.
You know, just trying to work through some of this, and
Yeah.
you know, it's very easy, I think, for all of us to get the big things, and you know, somebody uses a racial slur, we all get that. Where somebody makes a pass at a junior associate, we get that. That's bad. I hope we all understand that.
Right.
And I think that, you know, the real areas that are more difficult, and I've had these conversations with some, you know, older attorneys that I know, are some of the more gray areas. And, you know, for example, you know, I've had an older male attorney say, well, you know, I think of her, I treat her like I treat my daughter. And you know, I'm really looking out for her. I'm really caring for her. I'm protective of her. And, you know, that's one of those areas like, well, it's from a good place, but how does the board, you know, recommend we think about those things? How can we think about those things? How can we be better?
So I think probably there are two pieces to the answer. I mean, the first is how do we think about it, and how do we educate the person who's behaving in that way? And then the second is what do we do about it, and how do we communicate to the person who's behaving in that way in a way that educates them without alienating them? I realize I keep talking about not alienating people, and I also recognize that to somebody who is the subject or target or victim, I prefer not the word victim, of harassing or discriminatory conduct, the focus on not alienating the perpetrator of the conduct can itself be offensive. But my view, particularly in a gray area instance like you're describing, Chris, is that if you lose the audience, you lose the opportunity to educate and amend the behavior. And that the most effective way to amend the behavior overall is to start seeding the population of the bar with people who are behaving well and modeling that behavior. And over time, the inadvertent people, the gray area people, will presumably come into that. So, so the person who says, I'm treating her like my daughter, I think is superficially similar to the example I used against myself, which is, you know, if I'm behaving in a way where my behavior is different because of a characteristic of the individual, like race or gender, age, religion, the other enumerated characteristics in Rule 8.4G, then I really need to check up on amending that behavior. And it's a very fine line, because having a new associate, whether that person's young or not, in your firm is a good reason to pay particular attention to that person, be particularly supportive, be empathetic, and to behave in a way that might not be all that dissimilar from the way in which you would treat your child. But on the other hand, making it specific to how you would treat your daughter from your son, or a daughter from a male associate, is where you get into the problems. And I think it's really as simple as recognizing the individual and interacting with the individual based on that individual's needs, empathizing with those needs, identifying the interests that that person is either trying to meet or further, and addressing those directly. And that just sidesteps the issue using your example of gender. And I think we can all do that. I think anytime we're having an encounter with somebody and we feel impelled to act in a certain way, as opposed to responding to the substance of the interaction, when we feel that impulsion to react in some way, we should probably stop and say, why am I having this response? I think it's just good practice, by the way, and not necessarily for complying with the rule, but in ensuring that your interactions with other people are substantive and are powerful for you, understanding why you're reacting to something is really important. Does that address part one, Chris?
Yes. It does.
And then, so the second part of it is, what do you do if you see it? And in your example, the partner saying to a third person that you actually didn't identify the gender of the partner. I'm assuming it was a he. Is acting in a way, and we've been using a bystander intervention model that we can come back around to the issue of when and why and whether you should engage in bystander intervention. But here I would say this person hearing the supervising attorney speak in that way has an opportunity to directly communicate with the person and to show them that difference. And it can be done in a way that is laudable. It can be done in a way that is lauding, rather, commends the person for being concerned about ensuring that the associate's being supported in the practice, and simultaneously calls attention to distinguishing that support based on the individual from that individual's characteristics.
Just, one thing that it's just a little bit off topic, Justin, but one thing I found that, when I've seen some things, just kind of real low grade things. And that's why I kind of call these things, kind of low grade. Well, and, I think we also have a responsibility to ask the person, do they want help? Do they need me to say something? Sometimes they say, no, I got it, Chris. You don't need, I don't need you to help here. And sometimes they've said, yeah, maybe if you can pull that person aside and, just, try to, lead them a little bit. And that's something I think we have, my first reaction is to, well, I'm going to take care of this right now. And, that's not always helpful.
Well, actually, can I jump in there for a second before you go back? The issue of whether to intervene, how to intervene, and the risks of intervention are significant issues. When I was preparing for another presentation that focused a little bit more on bystander intervention, I spoke to a number of attorneys in advance, and quite a few said to me that their perception is that the net effect of having been saved or having been perceived to have been needed to have been saved, depending upon who I was talking to, would be worse than the net effect of whatever it was that some person thought they needed to be saved from.
Exactly.
Yeah, go ahead.
No, exactly. I was just.
Yeah. And so, I'm sorry, it's hard since there's the lag when you start talking. So there are different ways to handle that. It depends probably on the nature of your relationship with the different people who could be in the situation. With my associate, we talked about when and under what circumstances she might want me to step into something as she started as a clerk and became as an attorney over the course of our working relationship. And that didn't mean, when do you want me to step in because you're a woman? And that meant, when do you want me to step in all sorts of circumstances? Because I didn't want to undermine her professionally or personally, whether or not the issue was somebody mistreating her in some way. So if it's somebody you have that kind of relationship with, you can set some boundaries in advance. If it's somebody in public and you can make eye contact and essentially ask, you can try and do that. One thing I think that's really important is, at least for me, I try really hard, if I do intercede in something, to intercede for myself, not for the person at whom a behavior is directed. That behavior, and I wouldn't say this way, but I want the message to be, the behavior I'm witnessing is not acceptable to me in the context we're in, rather than you're being inappropriate to a person who needs me to rescue that person from the circumstance. Does that distinction make sense?
It does.
Yeah. Because I think that, assuming that a person needs protection is its own application of bias. And ultimately, the person may not need the protection, and yet it may be simultaneously true that the conduct is unacceptable. And we're to be self-policing. Even the Board of Overseers. I'm a lawyer. You know, my job now to educate and support and prosecute ethics violations. But I'm a member of your bar, and I'm subject to the same rules. So I think that those are the keys. Communicate in advance if you can. Communicate, and just so you know, I spoke to my male attorneys also about when they might want me to step in if a prosecutor was trying to take advantage of their newness or their youngness. So it's communicate in advance. Try and communicate at the time if you can, and consider that it's you who's responding to what you're witnessing. Consider owning it. I think all of those things go a long way to not undermining. Then ultimately, I think it's a decision to make. Is this a circumstance where I'd rather ask the forgiveness of the person receiving the conduct for overstepping rather than understepping? And that may vary from circumstance to circumstance. There are also options like delaying the communication with the aggressor. And so that's I said earlier, we worked on a 5D model, and I said you could directly communicate with the person. The second D is delay. Can be acceptable or appropriate in some circumstances to approach somebody later and say, hey, I don't think that was all right. Ideally, find a way that you're going to have a message that the person will receive from you and not merely feel castigated. But you can certainly do that.
And I'd just like to reiterate at this point, we've got 40 attendees right now. I'd really love to hear from some folks. This is, I'm sure people have thoughts on this. This is a chance for us to discuss these things, a lot of these issues, and I really would love to hear from some folks. But Justin, do you want some questions?
Sure.
So, some folks have asked about, the violation of their constitutional rights and some of these things, or their perceived constitutional rights and freedom of speech, and talking to someone. How do you address that?
You mean the violation of their constitutional rights not to have to engage, or that their rights are being violated in the context? I'm not sure which way the question goes.
Okay. I think not entirely clear. I think in their addressing of a person, I think that's what it's aimed at. Okay.
So, and again, getting into fraught territory. So, but there are people in the bar who believe that it is against their religion, or find that it's against their religion to be gay, for example. This is the most basic example. They're religiously intolerant to that, and who feel like being made to engage fairly, without bias. I say fairly, that's my own bias. Without bias, without harassment, to engage with a person who's gay requires them to compromise their religious beliefs. I think to some extent it's not the right question, because we're not asking them to be gay or support these people as individuals. What we're asking is for them not to discriminate against them. But more specifically to those people, we'd point out again that the United States Supreme Court has held consistently that attorney speech can be regulated, and that we here are not imposing a particular viewpoint. We're saying that attorneys may not engage in harassing or discriminatory conversation. And it goes in, or conduct, it goes in both directions. If a person was white, male, and not in suspect categories necessarily for that reason, but was an evangelical Christian and was identifiably espousing positions that went with that worldview, it would be equally a violation of Rule 8.4G for attorneys who didn't share that worldview to engage in harassing and discriminatory conversation or conduct, communication, where engaged that person. And I think that what gets lost in dialogue sometimes is that what we expect is civility and a lack of bias, expressed bias, and a lack of harassment, in that it's not specific to one side or the other of a particular issue. And I think that, and going back to your question about why it's not a constitutional issue, I think that it's essentially subject matter neutral. It may or may not feel that way when a person has been in a group of people who has historically been able to act in a non-neutral, unneutral way, is now being made to act neutrally. That feels like an imposition in a direction for them, but it's a direction to the middle, not to the other side.
We just had a note from Susan Sear. Susan, would you like to you just sent a chat note. Would you like to just to speak on this? You see a message here. No, thank you. Okay. Well, she just sent a chat to everyone about some of her thoughts, and I encourage everyone to read that. Justin, go ahead.
Was there something in Susan's comment? I have not been reading the chats because
It's I think it's just some
sure.
yeah. I don't know if you have a chance to read it or not, but
Yeah, I did, and Susan, I'm not trying to minimize the scope of what you're saying. If I've missed something more, I just didn't want to spend too much time reading while we're giving the presentation. But what I understand you to be saying is that if somebody is considerate to you, you don't necessarily assume that they're being considerate to you for a suspect reason, and that you're not suggesting people not act in considerate ways. And I think that makes perfect sense. And I hope I'm not suggesting that we all become cold and isolated and uncaring and unkind. What I'm suggesting is that we all try, and I certainly fail at this, and those of you who know me are going to laugh out loud to yourself, to be empathetic and warm and caring to everyone, as opposed to being limited to it. And to go back to my example of my young associate, when I realized that I was treating her differently based on very old conditioning, as a little boy and you hold the door for the lady, well, that's goofy. But hold the door for anyone who might be present and might appreciate going through the door is not goofy. And in your example, I would offer you a coffee, but I'd offer Chris a coffee too. And it's easy to think that the way, and I'm very easy to think that the way to avoid running afoul of discriminatory behavior is not to act. But an equally good way to avoid engaging in discriminatory behavior is to act warmly, openly, and kindly to everyone. And I think that addresses your comment. It's certainly what I try to do personally, however fallibly, and I think would encourage everyone in the bar to do. Because I think that we're at our best when we're supporting each other. I think we're at our best when we're treating each other well. I think we're at our best and that justice gets done best when all of us are comfortable to exercise our considerable skills and talents in the service of our clients, rather than having to reserve a part of ourselves for dealing with either defending or walling off this kind of conduct. Chris, I see another question came up there, it looks like.
yeah. So I'll just read it so everyone can hear it. It's a two-part question. Under the bar rules, do we have an obligation to speak to a fellow member of the bar who makes an inappropriate comment, sexist, racist, or otherwise, or is that a matter of personal choice? The question continues, I understand that silence can be interpreted as consent to the offending behavior, but it requires courage and thoughtful communication to appropriately address the colleague who made the comment, especially if it is a superior attorney. Not everyone has the requisite courage to challenge that person. It can be hard to know what to say. Is there an ethical obligation to report a member of the bar who says something inappropriate? At what point might it come to that? That's a great question.
I think it's a terrific question. And before I answer it, I want to acknowledge, and I don't know who's writing this, I want to acknowledge that I'm a white, male, straight, cisgendered attorney who has assumed a position of relative power in the bar. And then I'm sitting here telling you what you've got to do about stuff that can be very, very scary in the circumstance. So the short answer is no. We do not generally require under the rules that an attorney intervene. And now the person who asked the question said silence can be complicity, and that can be the case. And so that's something for an individual to bear out in the course of deciding whether to act and how to act. So back to our 5 Ds for a second. Maybe I should just name them and then get back to the question. So we've talked about directly communicating with the aggressor. We talked about delaying. One of the options is to distract. The fourth option is to delegate. And so perhaps there's an opportunity to delegate the intervention to somebody else. And that can include us, by the way, that delegation. If you feel like something needs to be done, but also feel like you're not in a position to do it for whatever reason. And the 50 is to document what happened, which is probably more relevant in sort of firm management instances than it is in sort of courthouse stuff. But back to this question, the rules do not require you to intercede. The sole exception would be if you witnessed something so horrendous that it raised issues of fitness to practice, and then you would have your standing obligation to report that. You need to be safe. In a former life, I was a firefighter medic. On the first day of school, they taught us a dead hero is no use to anyone. You can't run into a circumstance trying to save people where you don't have the stamina, skills, and confidence to do it and expect then to have a successful encounter. But I would hope that if there were something that you thought required intervention, but that you didn't feel like you could perform the intervention, I hope you would engage another resource at a firm or from us or the main assistance program or through a colleague. Inside the context of a firm is a much bigger problem. And we do occasionally get these calls from somebody in a firm who's witnessed misconduct by another person in the firm against a third person in the firm. And the balance between intervening and risking a job and maybe a career and not intervening is difficult and personal. You're not violating the rules if you don't intervene. The way you ask the question, anonymous asker, suggests to me that you would feel a moral imperative in the moment you're describing. There may be opportunities to engage somebody inside or outside the firm to help do some management stuff. There may be an opportunity to do that through us, but you're not required to risk your well-being.
Great. So looking at the time, Justin, I think we're about out of time. Do
Sure.
you have any closing remarks?
Just want to reiterate what I said at the beginning, which is that Bar Council wants to help you practice well. We're here principally to do that. We do the prosecutorial role when it's necessary, but we would so much rather talk to you in advance. Please call, and particularly about this stuff. We will maintain your confidences. If you call one of us specifically, we will maintain those confidences from each other if need be. We want to help you navigate this. If you've been on the wrong end or witnessed harassment or discrimination and you need assistance with that, call us. And if you're concerned about something that you feel like impelled to do but are afraid it's going to violate the rule, check in with us. Please, this doesn't need to be a hostile conversation, and especially where the goal is that we help everybody be well and healthy. So.
Thank you very much, Justin. I really appreciate it, you taking the time to be with us today. And with that, we're going to take it it's 10:55. Look at that for timing. We're going to start promptly at 11 o'clock with Chief Meade. So everyone can take it just a very quick 5-minute break. Normally I'd say go get coffee, but you're in your own homes, so we're offices, so you know where it is. So, all right, everyone, I'll see you at 11 o'clock in 5 minutes. Justin, we're still on live microphones. Just want to say thank you very much. I see Chief Mead's joining us. Chief, you just joined us. We're just taking a very short break, and we're going to start in just a couple minutes.
Okay.
So thank you very much for joining us, and we'll be back. And I told everyone at 11 o'clock promptly, so for 4 minutes from now.
Okay, I'll stand by.
All right, I'll be right back. So, Chief Mead, just to give you a sense, we're still on live microphones here, but we've got about 40 attendees, the majority of whom are from north of Bangor, I'm very happy to say. Just so you have a sense of who your audience is. I don't know if Steve Prince had given you that information or not.
Yeah, he said there'd be some folks from outside the county, but primarily folks from Aroostook.
Correct.
Okay, that's great.
Or Bangor and north, it's probably
Okay.
safe to say.
How long is the segment that you want me involved with?
However long you'd like to have. So,
Okay. All right. Well, that works for me.
Your show, and you're welcome to take as long or as little as you'd like to have. So, and we're going to have the people have the ability to raise their hands if they have questions, and they'll also be able to submit either questions via the question function or the chat function. So as those come in, I'll try to grab those and alert you and see if it's something that needs to be addressed immediately, or if we can wait until the end of your comments. So
Excellent. Do you have programming after this session as it goes into the afternoon?
No.
Okay. All right.
We do not. So
All right.
Normally we would if it was live up in Presque, but given the video feature, decided to do a 2-hour shortened presentation this year. So.
And people got ethics credits for the one that went this morning. Is that
Correct.
excellent? That's great.
So with that, we're about at the appointed hour. So I'm going to go ahead and welcome everybody back from the morning session. Now we're getting into the late morning session. Joining us today is Acting Chief Justice Mead. He's going to be offering some comments on the judiciary and everything that's going on with us right now. So with that, Chief Mead, please take it away.
Thanks, Chris. And thanks for the opportunity to see everybody, so to speak, at least virtually. I'd rather be up there enjoying lobster and a collegial gathering, but I guess this is the new normal for all of us. So hello to everyone. A special hello to those folks from Aroostook County. Those senior members of the bar may recall back in the 80s when I was a frequent visitor to your lovely county, litigating and doing workers' comp matters up there. Just a pleasure dealing with the bar. I truly miss it, and hope that we can get back to the regular picnic format in years to come. I want to talk to you about how the judicial branch is handling the COVID crisis. I know for many of you, it has been a time of relative inactivity. It's been quite the opposite for those of us in the administration of the court system. We've been on full screech mode since March, attempting to reinvent what we do. And it has been a daunting task indeed. So what I'd like to do is give you sort of a high-level view of what has happened and where we are right now, and then circle back for any questions. If you want to drill down on specific items or areas, I'm more than happy to tell you everything I can regarding those details, but I'll sort of paint with broad strokes in this overview that I'll start with here. And starting at the beginning, March 15, a dark time. I was just returning from a trip to Guatemala, got back late at night, and the Chief Justice called a meeting of the leadership at like 6:30 the following morning. We had no idea of what we were really dealing with at that point. It seemed terrible, and a lot of question marks, a lot of unknowns. So we responded by basically locking down the courts, stopping all proceedings. The courtroom doors were still open for filings, but addressing only those matters that involved a threat of harm to someone or someone dying or people with constitutional liberty interests. And this was the start of the complexity. We had different court locations. We're trying to protect our people and the public. We had to juggle staffing and locations and the needs that would occur in those particular areas. So it got complicated very early. But we also set out our overarching philosophical approach to what was coming, what we knew was coming. And our effort was to balance safety, meaning safety of the public and the profession, and our people who work in the courthouses, against the need to have access to justice. And as you can tell, that is a terrible, terrible dilemma, a terrible balancing effort. We've done the best we can to follow those overarching principles in the 4 months that have followed, but it's been quite the 4 months for sure. In the early going, we opened up the courts on very limited basis for those urgent types of cases we talked about. And in the meantime, tried to work on logistics and gradually opening things up, spreading it out. And then finally, by the end of May, we're sort of able to get our heads up above the water. In the meantime, we had issued something called Pandemic Management Orders, PMOs, which are really just quick and dirty administrative orders that would explain what we're doing and how we're doing it. The beauty is that they can be quickly and easily revised on the fly, and indeed they were revised on the fly to correct sometimes some inconsistencies. Other organizations like MTLA brought some things to our attention that would be appropriate to add to those PMOs. So they continue to be updated along the way. But we also, at the end of May, issued our phased reopening plan. It's a plan with 5 phases to it to get the courts operating again. Some folks felt that things should have moved faster. In reality, it's a very ambitious reopening plan. We have been scrambling to get our resources in order to do things safely while still administering justice in the meantime. But it has been, it's been a struggle. The early phases were just sort of baby steps, and we have proceeded through those steps, opening things up. We are right now in phase 3, and the objective is to get to phase 5, in which all case types and jury matters could be scheduled. The pandemic management plan is best read in the negative. It had cutoff dates before which certain matters couldn't take place. So the fact that all case types are, in theory, open for attention in August means we have to be ready with our resources to go in August. And it has been a real struggle to get things in place. You would think it would be a simple matter of pressing a button, but it isn't. Our philosophy on scheduling is that we do not want to gather large groups of people in courthouses and courtrooms. As you know, this virus is most virulent in settings where there are groups of people enclosed in areas, possibly with less than optimal ventilation. And that is the very definition of what we do in courthouses. We gather people in rooms for extended periods of time. So we are at risk of creating community transmission if we're not careful about that. We have implemented and will continue to implement and will enhance remote video court proceedings, Zoom proceedings like the one we're on here today, to address matters that can be addressed. Our philosophy is that if a matter can be addressed by remote video proceedings, then it will be. Certain matters simply can't, and those matters will have to take place in courtrooms. So we have mapped out plans to make that happen. We originally had capacity controls set at 10 with social distancing, and that resulted in situations where family members could not attend trials, the media couldn't get in. We've opened it up to a maximum of 50 people in rooms, but subject to social distancing. Our facilities people have gone throughout the entire state with tape measures, measured out the courtrooms, and figured out where people can be within those courtrooms, and those numbers include court personnel. And so obviously, there really is not a place where we have actually access to 50 to 50 shoulder-to-shoulder occupancy. But certain cases will have to proceed in the courtrooms. In August, all case types have been approved to proceed, including the 5 types of cases that have been held out to the end. Those are the large docket cases with some policy overlays to them, including evictions, disclosures, foreclosures, those types of gatherings. But in phase 4, even those matters are, in theory, able to be scheduled. Again, that implies that we have the wherewithal to do that. We actually, within the JB, put together a working group about how that is going to happen. I'll take evictions as an example. Many people are interested in this. There has been powerful advocacy on both sides of that issue, both by the folks who represent typically tenants, pointing out that being evicted in the midst of a pandemic where everything else is locked down is almost tantamount to a relegation to homelessness. On the other side, we have the folks who typically represent landlords, property owners, who point out that during this period, many tenants have been treating it as a free ride, and many landlords, particularly those who are small business owners, have been threatened with bankruptcy. I got a particularly compelling letter from a woman who lives from her rentals. So there are some policy issues, but these are also large docket items that are typically dealt with by large docket calls, where we bring in a whole pile of people. The judge gets up front, runs through the list quickly, decides which matters can be resolved quickly and easily. Those require the hearing. Those days are gone for the near future. Gathering, so I've heard that, I don't particularly care for this term, they call it a cattle call docket. We can't do those. That is out of the question. So we are struggling with how to handle these large docket matters. We are working on a plan that will involve looking at the backlogs, and they are enormous. They are absolutely crushing. Between small claims cases, evictions, and disclosures, we have almost 3,000 cases in the pipeline. These are cases that have been filed and ready to go. It's enormous, it's crushing, but we're going to try and triage those. And that will involve a clerk or a judge speaking with the parties, either by video or by phone, to determine whether there's any possible resolution to it. Can the parties agree on issuance of a writ of possession on a particular date? And if they can, then they'll go ahead and enter judgment on those. Some of them may be referred to mediation. Others will be actually scheduled for hearings. If the hearing can be done by remote video, it will be done. If it can't, then it will take place in the courtroom. That is a very complex process. Simply firing up a video doesn't get it done. Our clerks are going to have an enormous triage effort dropped on them in the meantime, but we are working towards it, and we're optimistic and hoping that that will get in place. we had previously adopted Google Meets as our platform for video, and we found it not to be optimal. It doesn't have some of the robust features that are present with Zoom, including the ability to have breakout conferences. If a lawyer needs to communicate with the client, they can be released and sent off, they can talk and come back. So Zoom will be our go-to platform. If you don't have a Zoom client installed on your computer, you may want to do it so you'll be ready for when that day occurs. September, in theory, permits jury trials to be scheduled. And this is a matter of great interest to the bar. It also is a very challenging step forward. Different states have experimented with different settings, none of which I found to be really optimal. We have a group within the judicial branch that is working on plans for jury trials. So, but I need to be clear, if any of you are thinking, gosh, September jury trials are a go, let me reassure you, at some point they will return to the way they were, but September may be a situation where we're piloting some jury trials in certain locations to see if our planning will work. It is a very, very tough nut to crack. We've had many, many suggestions from the bar, including conducting them off-site, renting space at the Civic Center where we can space people out. Some states have done that. It's kind of odd, but you have the big basketball court with chairs set out six feet apart in all dimensions. And the lawyers are operating with their backs to the jury during most of the trial. And the jurors deliberate in that sort of a setting. Not optimal, but we need to come up with something creative because this pandemic is going to be with us for a while. So that is sort of a vast overview of what we have been up to. As I said before, it's been quite exhausting. It is frustrating for us to the point of distress because the business that we're in is access to justice, providing people with a place where they can go for the peaceful resolution of disputes. We have a backlog of 5,000 Violations Bureau cases, traffic cases stacked up. And as I said before, we can't do a mass docket call like we've done in the past. We're going to have to somehow triage these through remote processing. When we call cases in to be heard in the courtrooms, we have measures in place. Cases will be scheduled so folks will not overlap. We do, first, Black versus Brown at 8:30, get them out of the courthouse, and then by 9:15, we'll do Jones versus Smith. It's a very slow process, and I'm afraid this is our future. And as we all know, what happens when justice is delayed? And it's causing us to tear out what little hair we have left. I have a few other topics I can talk about just as particular areas of interest to me, but let me ask Chris, are any questions flowing in yet? Any hands going up, folks who would like to drill down more deeply on any of the topics we're talking about?
I haven't, we don't have any hands raised, but just, a couple of the questions that I had, a lot of the folks in this call are from the northern counties, and thankfully the infection rate in north of Augusta has been very, very low. How is the court thinking about using that to the advantage of opening up some of those northern courts sooner rather than the more southern courts?
That is a good question. Our practice so far has been to have a single unified process across the state. As you know, the governor's plan is regionalized and ours isn't. We started with the process of trying to do regionalization, and the problem is the governor can say that these things can take place in the XYZ county, but we actually administer what is taking place. We don't run the restaurants or bars. The governor doesn't run the restaurants or bars or facilities in those places. So if we have 16 or 17 different regions with different rules applying them, we have an administrative staff that right now is spread beyond thin. We've driven our administrators to tears on occasions with what we're asking them to do. And for the present time, we find it difficult to the point of almost impossibility to have a regionalized process. But we're hoping to sort of split the difference, and in places where there is low incidence, will be sort of averaged in with the places where there are higher incidents, and sticking to that unified process of the state, at least in the meantime, until we have the wherewithal to run 17 different court systems.
We had a question, a question coming in from a attorney at Pine Tree. For years, we've been lawyers for the day in eviction court. Would it be appropriate for the court to refer tenants to us for consults prior to hearing? So that's actually an interesting idea. Is there any mechanism for the court to refer folks ahead of time?
Yeah, and that conversation is actually taking place. The court's in-house video proceedings work group has been in contact with Pine Tree and other providers. And they're working out the details, but I think the likelihood is quite likely. If it's going to proceed by video remote proceedings, we would find a way to loop in the Pine Tree lawyers, who are a great resource to the process. They facilitate settlement in many, many cases. And the details of how that would occur are still being worked out. But that concept is very much alive. I can say that with confidence at this point.
Great. Another question, have you considered an amnesty for non-flagrant VB cases to move the docket?
We have not at the administrative level, and there are executive aspects, the separation of power issues regarding that also. So we have not considered a unilateral amnesty process. That would have to be a subject of conversation with the executive branch.
And has there been a increased capacity for judicial settlement conferences in civil cases?
Yes, that's a work in progress. There have been a number of settlement conferences that have taken place in the criminal setting and in the civil setting and in the family setting. And we're having a fair amount of success with that. It turns out, somewhat to my surprise, that the video conferencing format apparently is conducive to the settlement process. So that is something that absolutely is appropriate. We have actually encouraged during our downtime when we were tinkering with remote proceedings, we encouraged our judges on their own to make themselves available for settlement conferences. We have also noticed in the context of protection from abuse matters, which involve obviously mediation type gatherings, that those have been quite productive, and the parties actually like it. They find that being able to communicate through video removes some of the emotional overlay that occurs when you get two people and a mediator or a magistrate in a very small closed space with the powerful emotions that are flying, sometimes feelings of disparity in power, that is quite an effective format. So we're discovering things along the way, and I think absolutely you will see more civil judicial settlement conferences occurring. One footnote to that though, Chris, I need to be clear about. As we are jumping back into this and addressing the backlogs, as I said, they're enormous. We are triaging them, and we have had in place for almost 2 decades a case scheduling priority list. And the folks at the top of that, as I said, are folks who are in danger of being hurt or killed, child protection matters. And we have very limited judicial resources. There are only so many judges to go around, and they're being deployed to the priority cases first. So for folks that have a civil case, even a compelling civil case, as long as we're still fighting this enormous mountain of backlogs, it may be a while before we can fully deploy the judicial resources to civil settlement conferences.
Okay, just another, it's kind of a, it's not a question, but it's a comment regarding communication between attorneys, the bench, and the courthouse. There was an anecdote from one of the district courts where the judge required a party to be at the courthouse in person, but the court marshals would not allow the person into the building because they were from out of state. So there was a problem there, and I don't think I'm not really looking for you to, if you have any guidance on that, that'd be great. But I guess that's more of a question of just can we have probably just greater communication between all the parties, especially alerting the bench that this might be an issue, that this person may not be allowed into the building. Are you aware of that sort of thing? So
I was not aware of that instance.
I meant just the practitioner should let the judge know.
Yeah. Our policies will guide that decision-making tree to a large degree. If it has been determined that a case cannot be resolved except by an in-person appearance, then it would be set for an in-person appearance. If the person is from out of state and subject to the quarantine or other out-of-state requirements, that would still be the case, and that person would be denied access to the court. I mean, there's talk about people who are following and not following the quarantine requirements. I mean, these are executive orders, so we, as a branch of the government, are going to absolutely follow those strictures. So I was asked sort of generally in an informal conversation with the judge, what should we do with those situations? And I would say, ideally, it should be determined ahead of time. If someone is being compelled to appear and would not qualify for entry to the courthouse, that should be addressed before the fact, without a doubt. If the person does appear and is not allowed access to the court, then the court, we, should be able to come up with some alternative approach that would allow the person to participate remotely. That actually did happen early on back in I think, April, where a woman coming to the courthouse seeking to file a petition for protection from abuse came to the entry screening, and there are questions. We don't use the thermometers, but there's a series of questions. And the marshal asked those questions, and she answered in the affirmative, basically to all of the COVID symptom questions. He said, you can't come in. And of course, she was quite distraught by that. But they're able to procure an iPad and have her stand outside and have the dialogue with the court. It was a very ad hoc, cobbled together solution. But that happened there, and I think it calls for creativity. So if that situation were to repeat itself, and I hope it won't, as we get better and better at this, hopefully when judges or clerks schedule matters for in-person hearings, they will inquire whether there is any restriction or limitation on the people to enter into closed spaces. But if not, we've got to be creative. We've got to be clever, because these are the halls of justice. We need to allow access by hook or one means or another, complying with the standards of the law. I'm sorry to hear of that situation. Hopefully it won't repeat itself.
I think it was more of just a things to expect while we start to open up, and
Okay.
things are really difficult as we all figure this out. And we just need to remember to live under the Latin maxim of semper gumbi, always flexible.
Yes, exactly.
So Chief Mead, so those are all the questions I had right in front of me. So if you wanted to address a couple of those other issues, that'd be great.
Sure. And, I've had a couple of concerns that are kind of near and dear to my heart. I've never heard semper gumbi before, so that's probably a good one. What we've struggled with on the court side is, my feeling is that we need standardized processes. That's what we're working with on the video remote business right now. So far, when lawyers have asked, and frankly in a couple of sessions with MTLA, about specific situations, how to deal with them. And the best answer I was able to give is that scheduling at this point, of course, we're talking back in June, is very localized because we weren't able to promulgate statewide practices. And we have learned that different regions, different judges are handling things differently. And I want to stop that. I want to have standardized practices taking place in every courthouse. So if you go to Wiscasset or Fort Kent, you're going to know exactly what you're walking into. We don't want different local rules. In order to do that, I think there are many people, both on the bench and the bar and in the public, who are quite optimistic and hopeful that this siege will lift and life will return to normal in the very near future, and are resistant to gravitate to new normal kind of practices. But we don't have the luxury of assuming that. Actually, the latest prognostications are ominous. Some of these scientists are saying, hey, 2022, we're still going to be, the best we can hope for is having a handle on minimizing community transfers. One of my colleagues sent me a report from MIT scientists today that said that the best practice is that anyone over 65 must basically shelter in place for 18 months. And while the prospect of an 18-month vacation sounds good to me, it has an ominous ring to it, which is that this is going to be here for a while. So we have to plan that 2021 is going to look pretty much like where we are now. We want to have uniform practices. We need to emphasize remote video proceedings because there are only so many people we can get into so many courthouses. And if you do the math, we have the backlog and the cases that are rolling in. And with that level of people coming into courthouses, that is just going to continue to expand. That's what keeps me awake at night. It wakes me up. So remote video proceedings is basically our equivalent of the face mask. It's not great, but it's really the only thing that we can do in the meantime to address this. So our decree at some point will be that video remote recording is the default. It's the mandatory, unless there is some reason why it can't take place. And that will be a judge by judge decision. We talked about many people, particularly in the PA and the PH realm, don't have access to the hardware, or even if they have the hardware, not the bandwidth or even the savvy to jump onto a video conference. So one of our possible resolutions to that is to set up banks of video terminals, which be glorified computers where people can go, social distance and mask and participate in these remote conferences, maybe even in courthouses that are large enough and have gathering areas. We are still looking at creative solutions, but we probably have to get away from the Semper Gumby approach. We need to have some rigid, clear directives in place. I assume everybody listening here has checked into the Judicial Branch website and looked at the PMOs and looked at the plan. And that's where the latest breaking stuff will occur. Our information people usually do a press release when something new has come up. For instance, probably as we're speaking, we are locking down applications to take the bar exam in Maine. We have a rolled back date of September 30th to October 1st for anyone wanting to take the Maine bar exam. We have been flooded with folks wanting to take it. We've been given preference to Maine residents or people who'll be practicing in Maine. New York just canceled basically their UBE bar examination, which means a large number of people are going to be scrambling to take the UBE in other states. And we have locked that down as of today. If you're not in, you're probably not going to get in, at least to take the Maine UBE at this point. But the PMOs are the latest and greatest, down and dirty AOs telling where we are.
We just had a question come in, if you'd like to take it now.
Sure.
There has been pressure to make criminal misdemeanor pleas easier as a means of working through the backlog. I am concerned that the pro se defendants are being pressured into making uninformed pleas in order to manage the backlog. what protections are being put in place to ensure that defendants' rights are not being exchanged for expedience?
That one, I'm probably going to defer a little on. There's some very high discussions taking place about whether, by statute, lawyers of the day and other people should be mandated or prohibited, and whether the prosecutors can reach out directly to unrepresented individuals in advance of the court date to talk about resolutions. So there are some real policy issues at place there. People are talking about legislation. So I think for the moment, I've got to back off on that because there are executive branch issues that come into play on that. It is a matter of concern, and I'll leave it at that.
Does the court, there's a lot of talk that the legislature is going to be coming back into session, at least temporarily. Does the court expect any impact from that, any changes from that, or just wait and see?
We're sort of in the wait and see mode. We have folks who monitor the legislature very closely, and as you know, some of the committees are going to be gathering to talk about bills that were shelved back in March and whether they can go ahead. Some of those are of interest to the judicial branch. Whether or not the legislature will return in any sort of way where they can actually act on the bills is a question mark at this point, but the committees are going to try and gather in the meantime. We're watching that with great interest. One of our esteemed judges, David Mitchell, who presides sometimes in the county and sometimes down east, is up for reappointment and is into his extension period right now. So he is watching that with great interest. If he is not reappointed by the end of December, his commission expires and he is no longer a judge. So that to us is unacceptable. And we are watching that aspect of it with great interest. But as to when and how the legislature will reconvene, we don't know. One of the other, this is a little bit off topic, but as you know, there are CARES Act funds that have been received, which the court truly needs. As you know, the CARES Act funding is for organizations and entities that have incurred COVID-related unanticipated expenses which are not budgeted for. And I think the judicial branch has a couple of cases made to order for that. In order to equip all of our judges and clerks with Zoom licenses, it's a little more complicated than it sounds. We're going to get upwards of $100,000 invested into that, not budgeted for, and then looking down the road with revenues being down and needs going up, we have no idea what the future holds. I've heard predictions of a parade of horribles. I've heard predictions of government entities stepping in to backstop government functions and private functions. We have no idea at present. We've made a request for the CARES funds, but how that is handed out is still quite a question mark. And the executive branches in many states who are charged with doing this are a little gun shy about handing them out because part of the catch on the CARES Act expenditures are if the executive hands out some money that turns out that really wasn't what it was intended for, they have to pay it back. They have to send it back to the federal government. So it would be irresponsible of an executive branch to go ahead and say, well, maybe this is covered, maybe it isn't, let's go ahead and do it, and then have a budget buster, payback down the road. So it was a simple question, what's going on with the legislature? We have no more insight, I think, than anybody else does, but a great deal of interest.
Thank you. Those are all the pending questions I have. If anyone has questions, again, either through the question and answer, or you can also raise your hand and I can turn your microphone on and you can directly ask a question if you'd like to do that. With that, Your Honor, I don't see anything coming in. As they come in, I'll let you know, but if there's anything further you'd like to discuss, the floor is yours.
I would just say access to the courts and information is open. Almost all of our locations, with like one or two exceptions, are staffed. There are people who can answer the phone. If you have questions about what's going on, You can call your court. We also have an court information officer, Amy Quinlan, who fields multiple questions during the course of the day. We had considered doing something like what the governor has done, which is briefing to get the word out, and ultimately decided against it. But organizations like MTLA, MSBA, bar associations have invited us to be present to kind of get the word out. So this and the website are our platforms for doing that. But lawyers should not feel isolated. They can call their courts and ask what's the status on this and hopefully get an answer. And if they can't get an answer, they can pass that up the line and hopefully get to an answer. The big ticket questions are, when is this all going to be over? We don't know that. We are planning for the long run, and our plans as they evolve will be on the website. And I do want to emphasize, we have great people in the judicial branch. I mean, I hope that is the feeling among the bar also. We have a terrific cadre of judges, dedicated clerks in the clerks' offices. They are doing their best to deal with very difficult situations, and our administrators, whom you never see, you never interact with. We are flogging them unmercifully, getting numbers and data and asking them to institute new procedures, asking them to create working groups and get back to us with responses. And they're going full tilt, and I just can't say enough about them. We're all exhausted. I'm tired. We've had really no break for the last 4 months, but we are dedicated and committed to the administration and access of justice and doing everything we can to get those wheels rolling. So, and I appreciate the opportunity to pass that word along to anyone who will listen.
One more question just came in, and it's a big one.
Okay.
Status of the e-filing program.
That is a big one. As you know, we've had a long process moving us towards a new case management system, the Odyssey CMS, and also its partner, the e-filing system that goes with it. We were slated to have that go live in Region 5, which is Bangor and the surrounding regions. The original plan was to have it for all case types to go live in October. Even before COVID hit, we dialed that back to just very limited case types, basically some civil matters, which would be mandatory e-filing, and the CMS would be in place for that. The current status on that is, obviously there need to be rules of court to govern access to the case management system, the database that exists, and also the rules for e-filing. We did a presentation at the MSBA winter meeting where we delved into some of that. We had an informational session here in Bangor. The rules, which you'll find in due time, will be called the RECS rules, the Rules for Electronic Court Operations, RECS, something like that. The RECS rules have gone through multiple iterations. They've been posted for public comment, gone back, redrafted, posted again. The e-filing rules were promulgated, posted for comment. We've got those. And the SJC is working with them. We need to have those in place before anything goes live, but I'm confident we will. We're very, very close to working those out. The other question mark in this is rolling out the e-filing and CMS system will be labor intensive for our IT department and also our administrators and our clerks, very intensive. Rolling out the remote video court proceedings process will be very labor intensive on our IT people and our administrative people. And as you can sense, there's a bit of a tension between those two processes, and perhaps that is what prompted the question. We just completed a meeting this morning with the project oversight group. The chiefs have been meeting. The SAJC has been meeting. As of this moment, which is, what time is it? 11:40 today, we are still on track for the pilot project in Region 5 to start in September. And that's all I can tell you as of this very moment here. There's possibility it may be modified, maybe deferred, maybe all systems go. don't know at this point. We are gathering information, intel, cost estimates, and things that will allow us to make an informed decision. It will be, as you know, I assume the questioner knows, it will be mandatory where it is implemented to use e-filing. And that shouldn't be a source of distress or intimidation to lawyers. It's very intuitive. Actually at our informational session in Bangor, we invited lawyers and also administrative staff, the people who usually handle the nuts and bolts of some of the filing. And I would say the attendees were probably 20% lawyers and 80% administrative staff, secretaries, administrative assistants. And I think it was well received. So the other thing we're dealing with with the rules is in certain places, the Rex rules overlap or in rare instances conflict with the court rules, family court rules, civil procedure, criminal procedure. So in those places where there would be a collision, it is likely that the rule will be that the Rex rule overrides the others. But as with everything else we're doing, there are levels of complexity to this that just absolutely boggle the mind. So it was your question asked a very simple question, and I've given a very complex answer, but the subject matter is complex. As of this moment, the rollout is still in place, but stay tuned. Any announcements would be appearing on the JB COVID page and would be the subject of a PMO and a press release.
It's a nice cliffhanger there.
Yeah, I'm sorry. Believe me, we're the people on the cliff like this, and making decision to jump or climb, and it is not an easy one, believe me.
We just had another question come in. Should the bar be encouraged to use referees to help move forward with the backlog? Or I guess the corollary question is, how can the court encourage the bar to do that?
Yeah, that would be great. As we are reinventing what we do, I'm guessing lawyers are reinventing what they do. As we know, as Chris knows, there are special rules for depositions that are addressing the situation. And lawyers realize that in order to move the dime, to move their cases along and serve their clients, that the courts are not as robust a resource as it has been in the past. And taking matters to referee, to mediation, to arbitration, absolutely, I think is a good approach, both for the bar and it's beneficial to the court. And yes, it should. Should we encourage it? Yes, I'll say right now, I encourage you to do that. I should be more affirmative about that and make it more motivational. We may. That's on our list of, Chris knows this, we had a stakeholders meeting some months ago and received many, many suggestions coming out of it. I'll just show you for a second here. We received live comments and written comments, and I have reduced them to a binder that consists of 200 pages of folks, stakeholders who have been affected by the COVID crisis with suggestions, good suggestions, some of which can be implemented right away and others are much more complex and systemic. And we're doing the best we can. With the luxury of time, I would address every one of these in here, but these are valid stakeholders with valid concerns, and we just can't address every one of them along the way. It is deeply, deeply frustrating. Mediation, arbitration, referee, absolutely. Please do that if you can. And thank you for raising that possibility.
Well, with that note, Your Honor, we are through the questions, and if you don't have anything further, we can wrap up.
I would just say thank you again, and thank you for everyone who signed on, and a particular hello to my friends in Aroostook County. I look forward to seeing you at a picnic with live food and drink and good company.
Well, thank you very much, Your Honor, for taking the time today to bring us up to speed, and we look forward to hearing from you again. The MTLA will be providing future CLEs, hopefully as things progress forward. There's going to be a lot of happenings in the next couple months, and we'll try to keep everyone informed. So with that, I'm going to say thank you to all of our attendees. We've appreciated you joining us today, and we'll be getting emails out in the future about future events. So with that, we can go ahead and wrap things up. So thank you very much.
Thank you. Bye-bye.
Recording is stopped. Mics are still live. Actually, Chris, you have to stop recording now.